strange days that we're living in right now. I don't think any of us foresaw what 2020 has evolved into at this point. I want to talk real quick about kind of a how-to video, but this isn't a how-to video in what you might be thinking. This is a how to stay out of jail video. I've had a lot of people who have emailed me, commented on videos of mine, and just outright asked, okay, some of the videos that they've seen where, more notably, really in California is where I've seen the most of it. Go figure, the strictest gun laws where criminals know they can get away with these things. But they're having their protests where people are riding down roads. I don't know if it's freeways, boulevards, or whatever, but it's public roads. And it's roads that they have the right to be on. And if you want to protest, I guess you have the right to be on there too. But you are breaking the law if you're actually obstructing traffic in any kind of way. And not only are they just in the way, that's something that's different. I guess you've seen protests like that in the past, and they can come across as being acceptable, just if they're nonviolent. But these are not like that. These are videos of people who are vandalizing, hitting at, kicking at the vehicles, trying to break windows, grabbing door handles. And I've had people ask me, what happens if I'm in that type of situation? Now, keep in mind, guys, I am in the state of Louisiana. Everything I'm talking about right now is based on statutes in the state of Louisiana. You will most definitely want to pursue any information that you can looking into statutes in your own state to make sure that you do not follow statutes in the state of Louisiana that may not apply in your state and you wind up in jail anyway. The information I'm going to be talking about today will keep you out of Louisiana jails, strictly in the state of Louisiana. So, if somebody is attacking me in my vehicle, can I shoot them? The simple answer is maybe. And it's a maybe because you, as the victim, and you're a victim now because you haven't shot anybody yet, but you as the victim have to make some decisions on your own, just like we all do. And look, guys, many of these decisions you have to make, they're split-second decisions, but so many of them are common sense and basic human decency decisions we have to make on a daily basis anyway. It's not like you have to go through this Scantron test and mark down A, B, C, or D. Let me explain that. Let me go a little bit more in depth. I will post the links of where I get this information, but again, this is the statutes in the state of Louisiana. More notably, Title 14, Criminal Law, RS 1420, Justifiable Homicide. Okay, justifiable homicide. A homicide is justifiable if, 1, when committed in self-defense by one who reasonably believes that he is in imminent danger of losing his life or receiving great bodily harm. Now, I'm trying to specify certain things in here to make sure that everyone knows that this is not some just open-ended thing. I want to point out the things that you need to pay attention to. Again, notice it says, who reasonably believes that he is in imminent danger of losing his life or receiving great bodily harm. Number 2, a homicide is justifiable if or when committed for the purpose of preventing a violent or forcible felony involving danger to life or great bodily harm by one who reasonably believes that such an offense is about to be committed and that such action is necessary for its prevention. And then it goes on to elaborate a little bit more. A homicide is justifiable when committed against a person whom one reasonably believes to be likely to use any unlawful force against a person present in a dwelling or a place of business, or when committed against a person whom one reasonably believes is attempting to use unlawful force against a person present in a motor vehicle. So it's specifying motor vehicle here just to make it clear. Places of business, your residence, or they spell it out specifically so that there is no question here, no gray area in your motor vehicle. Number 4, a homicide is justifiable when committed by a person lawfully inside a dwelling, a place of business, or a motor vehicle against a person who is attempting to make an unlawful entry into the dwelling, place of business, or motor vehicle, or who has made an unlawful entry into the dwelling, place of business, or motor vehicle, and the person committing the homicide, which means the shooter in this case, I call him the victim, the person who is actually being attacked, committing the homicide, if you reasonably believe that the use of deadly force is necessary to prevent the entry or to compel the intruder to leave the premises or motor vehicle. Now that's a weird little area right there, because you hear, especially in concealed carry classes, that if you are drawing your weapon, you need to be prepared to use it. In fact, what they mean by that is this is not a brandishing thing. You should never remove your weapon from the holster or from its concealable nature unless you actually intend to use it. It's not there to scare somebody. You should not be pulling it unless you feel like the next step is pulling the trigger. So it's interesting that it says to prevent the entry or compel the intruder to leave the premises or motor vehicle. I guess in that case, the thing you would want to do is draw your weapon. And if you have to verbally tell them, I'm going to defend myself by any means necessary to prevent you from harming me. In so many words, I'm paraphrasing. Obviously, you may not be able to get all of that in. Now, it's important that I point out a couple of things. Now, I'm going to go back and forth real quick. I want to leave the statute for a minute because a very good friend of mine who's an attorney here in Lake Charles, Louisiana, Shane Hinch, he has his own firm here in town. He sent something to me that is basically a write-up on things that have happened in terms of the way this law has been administered and how it's been carried out, and cases that pertain to it. And I'm going to read this real quick. And the reason why I'm doing this is because I want to make sure I spell out that this is not, the law that I just read you is not an open-ended permission slip, if you will, to just shoot people who are coming at your vehicle. And I'll tell you why. What Shane sent me is, he says, Louisiana Revised Statute 1420 entitled Justifiable Homicide provides guidance on the circumstances under which a killing may be considered justified under Louisiana law. Shane states in here that in order to successfully have the justifiable homicide rules applied, a shooter must be able to, 1, show that the deceased was attempting to or had made an unlawful entry into the shooter's car, and 2, whether the shooter reasonably believed that the use of deadly force was necessary to prevent the deceased from entering or to compel him to leave. Again, a condition as to hopefully seeing the gun and they would leave. Now, Shane cites a case from New Orleans, and I'm going to read this. A case from the New Orleans area showed the application of these principles. In State versus Gasser, the defendant shot and killed a man he alleged was entering his car after a road rage incident. Bad situation, road rage. That's a bad situation to introduce a gun into. The defendant, Gasser, was charged and tried with second-degree murder. He argued at trial that the deceased made an unlawful entry into his car, that his subsequent use of lethal force in response to the victim's entry was presumed reasonable. The defendant was convicted of manslaughter and argued on appeal that his actions were reasonable and that the homicide was justified. The Second Circuit found that the evidence, expert testimony on blood splatter and gun ballistics, showed that the deceased had only leaned on the defendant's open window and then was shot and killed. And what they're specifying there is evidence was proven that the man had not forcibly entered the vehicle and was not in the vehicle or was not trying to forcibly enter the vehicle himself. He had simply leaned onto the window itself. The open window, the window was open. Keep this in mind. Additionally, the Second Court considered whether use of deadly force was a proportional response to the force used or threatened by Mr. McKnight. Ultimately determined that it did not. We find that the amount of force employed by the defendant was a disproportionate response to Mr. McKnight's actions, Mr. McKnight being the man who was shot and ultimately killed. Now, this is where I'm going to leave what Shane sent me and go back to the statute real quick, because these things are tied in. The statute states also, for the purpose of this section, there shall be a presumption that a person lawfully inside a dwelling, place of business, or motor vehicle held a reasonable belief that the use of deadly force was necessary. Now, I mentioned that they were in there lawfully. Keep this in mind now, okay? That the person doing the shooting has to have been where he's at lawfully and not committing a crime. A person who is not engaged in unlawful activity and who is in a place where he or she has a right to be, again, they're lawfully there, shall have no duty to retreat before using deadly force or as provided for in this section, and may stand his or her ground and meet force with force. I bring that up because one of the things that Shane also sent to me was this case also cited other cases where Louisiana courts had found the amount of force to be unreasonable. Among these cases was State versus Mays. This case was tried in Beauregard Parish by Judge O'Neill. The defendant was charged with second-degree murder after shooting someone following a verbal altercation at a wedding. The defendant claimed at trial he acted in self-defense because the deceased lunged towards him or shoved a table towards him. Responding to an oncoming table or lunge by shooter is an excessive response, the court found. My reason for bringing this up is in the Mays trial, court did not allow the defendant to argue and include in the jury instruction that he was entitled to stand his ground. The state successfully argued to exclude this instruction because of their argument that the defendant was engaged in unlawful activity during the instant shooting. The state argues that the defendant is not entitled to the benefit of subsection C and D. Why is that? Well, because the defendant who did the shooting, who felt threatened, pulled his gun and shot somebody, was a convicted felon and carrying a weapon, so he was not entitled to the instruction. If you are in the process of committing a crime, or if you are doing something illegal, if you are selling drugs and you feel threatened, you cannot lawfully shoot that person. If you are, this is where the gray area exists. Let's say you are in that vehicle and somebody is attacking you. My guess, I'm no cop and I'm no attorney, but based on what I've read right here from Shane and the actual statute, you better not have a bunch of weed in the car. You better not have anything stolen in the car. Heck, I wouldn't even have wanted to be speeding in the process of doing all of this for fear that that would be the reason why I go to jail, because I was in the commission of a crime during my shooting somebody else to defend myself. The whole point of the video that we're putting together here is obviously to keep you out of jail. You have got to make these things perfectly clear, and these assessments that you go through quickly, and your mind will go through them. Even though there's tunnel vision and adrenaline flow, your mind will go through these things and determine if it's a true threat. In the case of Mr. Gasser, the gentleman who was supposedly attacking him was doing so by leaning up against his vehicle. The man retrieved his firearm and shot him. Again, adrenaline's flowing, you're mad, you're upset. The guy pulls the gun. Maybe even told him, don't lean up against my car, don't touch my car, something like that, and shot the guy. We have to make these assessments on the fly. We have to make sure that when we are protecting our family, that we are not using the wrong amount of force to combat that force. We have to meet that force with the equal amount of force. I know guns are great equalizers, but we have got to make sure that we're not out there just trying to be the Wild West. We see it in comment sections on Facebook and YouTube and all that. If that son of a gun does this, I'm going to shoot them or something like that. That's not how responsible gun owners operate. We have to go through our list of things to make sure that we are making the right decision, because not only is this impacting the other man or the attacker's family, obviously, you are now going to be drugged through the court system, and you don't want to be there. Now, you do want to make sure that your family, they all arrive home safely. So that's where I draw the line, meaning that if somebody is seeking to do me or my family harm in my vehicle and they start busting windows to gain access to me, we may be reading this statute all over again, because I'm not going to let it happen, just like I don't expect anybody else to do it. But I'm going to know at some point that that person has crossed the line and that they now are going to be met with the same amount of force that I feel like they're pushing towards me. It's so important, guys, that we react and respond as responsible gun owners. Guys, I want you to stay out of jail. That's the whole reason I put this together. Again, this is not a how to shoot somebody. This is a how not to go to jail video. And I hope you guys will educate yourselves, look up the statutes in your particular state, and make sure you're educated. Disseminate that information. Give it to your friends and family. Make sure that as many people as you know these things. And let's not get ourselves in trouble. We're not doing our families any good whenever we're sitting in a jail cell.